affected by these things. America, of course, has one of the highest divorce rates in the world, and when we're talking about estate planning, this means in many cases people have been married more than once, and this creates additional complexity and opportunities for discord in the estate planning. Of course, a big worry for the clients I meet with are the danger of nursing home expenses and long-term care expenses. I took these numbers out of a Houston paper here that came out a couple of weeks ago. It said that the average nursing home in the Houston area, the cost was $7,441 a month on average for a semi-private room in a nursing home. So that's about $90,000 per year. In the previously, I've been using some other statistics that had a lower value, but this is the most recent information from Genworth. But in whatever it is, $5,000 to $7,000, it's typically a tough burden for families. Since 2013, nearly 2 million families have filed for bankruptcy due to crushing medical expenses, and this is another worry that faces many families and many working people. And finally, as you all probably are well aware, there's a huge number of people that spend a lot of time taking care of mothers and fathers and elderly brothers and so forth. So the assisting people who are no longer able to fully take care of themselves is a huge job for millions of people. And as those baby boomers get older, it's only going to get worse, presumably. So it's a concern. Then because of poor estate planning, there are millions of lawsuits and court fights. And even when it doesn't go to court, it's not a lawsuit. But poor estate planning often creates a lot of friction, sometimes unnecessary friction, in the settlement of estates. So it doesn't add to the family happiness when this happens. So in talking to clients, here are the 6 major concerns for people when they're thinking about their estate plan. First, we want to pass on our hard-earned wealth with the least amount of taxes and regulatory requirements, court requirements. Secondly, obviously, we want to avoid any unnecessary taxes and fees for our spouse, the surviving spouse, or for our kids or beneficiaries. Third, we'd like to avoid going broke in a nursing home. So I know this is a big concern for people, or for people who don't have Medicare, don't have health insurance, then the danger of severe medical expenses, high medical expenses, is a huge worry. And after we're gone, we would like to protect our spouse and kids from being taken advantage of by others. So that's certainly one of the concerns things that worry the families that I talk to. And of course, after we're gone, we'd like our family to come together, not come apart. But in some cases, the estate, from some families there's going to be conflict. But if the estate is poorly planned, it can accentuate that greatly. And last, we want to pass not only our money along and our property along, but everybody, if you think about it for a minute, we'd like to pass along good family traditions, something about the experiences we've had and the closeness we have with our family. So there's a whole other dimension of estate planning that a lot of times is not reflected in the bare documents that people create. So here are the 6 major concerns. No government if we can avoid it. No taxes or fees if we can help it. Avoid nursing home costs. Avoid creditors and predators for our kids and loved one, our spouse. Avoid family fights. Pass on our wisdom and family traditions. So everybody knows we need to do that, right? But knowing's not enough. The old saying, everybody knows, well, if you want to lose weight, and a lot of people have New Year's resolutions around that, right? We got to do 2 things. We got to eat less and move more. Unfortunately, knowing it is little help, right? We got to actually do it. And so estate planning is sort of in the same category. For many of us, we know we need to do something. We need to update our old documents, or we need to get something fresh in place because things have changed. And so we want to do that, but We got to actually do something. So one of the things I want to help you to do today is help you move to action on that. As we get started, let me give you a little bit of background on me. I was born in Dallas. I grew up in Dallas. I went to college at Southern Methodist University. And I graduated in 1968, in May of 1968, right at the height of the Vietnam War. And when I graduated from college, I finished my last exam at Southern Methodist University in May '68. I went home and I looked in the mailbox that day, and I had a draft notice from the Army. So my occupational choices were set at that point. So I went into the Army. I never intended to make the Army a career, but I never got out. So I was in from '69 to '89. I retired as a lieutenant colonel infantry. Now, during college and during the Army at different times, I said, well, at some point I'm going to get out and go to law school. So when I retired, the next month, I moved from Montana to San Antonio and started law school. When I finished law school 3 years later, I came to Houston. So that's how I ended up in Houston. And I went to work for Arthur Anderson. At the time, it was it was the largest accounting firm. Of course, later, it was infamous because of the Enron stuff. But when I was with them, they were going strong. And they had a huge office here in Houston. And so they hired a few attorney CPAs to work in the tax department. So I worked for them for 2 years in that role. And then I started my own law practice. Now, when you start a law practice, one thing you could do is family law, right? And family law, it sounds nice, but actually it's about divorces. And divorced people are unhappy when they're divorcing, and they want their attorney to be unhappy with them. And so I didn't think that was too productive. I'd also thought that when I was in law school, I would be in litigation, but I'd done some internships during law school, and I wasn't too pleased with that. So then another thing you can do when you're starting a law firm, of course, is you can defend criminals. But I don't really like being around criminals, so I didn't think that was a good line of work either. So what I did is I thought, well, I'll do estate planning and probate, and this is a constructive way to work with people, and I'm not planning to do litigation. So I thought it was a constructive way. And so I started out to make the law firm work on that basis. We've always done that. The law firm has been in the Greens Point area since 1994, and so we've been there a long time doing this work. Now, over the years, I've had the chance to help thousands of Texas families. And so I have clients all over from Kingwood and this part of town all the way to the west through Spring and Woodlands and so forth. So I know and the team at the law firm knows this is great work to be able to help people with their families. And so I've taken it as my calling, and that's why I'm still standing up here talking to you today. So I hope I can help you as well. Now, a couple of years ago, 3 years ago, I joined the American Academy of Estate Planning Attorneys. And they're a organization, a national organization, and they work just with estate planning firms. And there's about 150 law firms in the United States. And the reason I joined them is because I wanted to make sure that our law firm kept up to the highest standards and that we had the best documents. So that's the reason that I'm a member of that. Are you guys starting to get hot? Or is it just me? Okay. Now, Money Magazine says if you're looking for a estate planning attorney, one of the places to look is at the American Academy website for an attorney in your area. Susie Orman in her book says, check the website for American attorneys. In addition, as I mentioned before, I'm board certified in estate planning and I'm a CPA as well. So with that, let me congratulate you guys on being here. We're going to talk about death and taxes. We're going to talk about nursing home expenses, families torn apart, and your plan may not work. So that's a heavy load for an afternoon. So I appreciate you all coming to look at that. But it reminds me of, remember Benjamin Franklin said that only two things are certain in life, death and taxes. And some person after that said, yeah, but death doesn't get worse every time Congress meets. So now, why don't we get our estate planning done? We know we need to do it. Well, of course, we can procrastinate. Now, the story I like to tell is, remember the book, 7 Habits of Highly Effective People, Stephen Covey's book. He talks about there's 4 categories of activities in our lives. And the first category, or quadrant, is stuff that's urgent and important. And if we're going to be confident people, we have to do the stuff that's urgent and important. So that's one quadrant. We do that. And then there's another quadrant, and it's urgent but not important. And that's like the cell phone calls and the text messaging and checking our emails and all those things we get involved in, and we feel like we have to do them. But probably in the great scheme of things, they're not very important. And there's another quadrant, and that's the stuff that's not important, not urgent. And that's where you get to drink coffee, watch TV, shoot the pool, play golf, all that kind of stuff, right? And then there's one more quadrant that causes all the trouble in life. It's stuff that's important and not urgent. And that's where estate planning lands. And that's why it's so hard to get it done. And it's like a lot of our hopes and dreams and other big projects, they get lost in there. It's like there's a procrastination monster, and he snatches this stuff up there, and you can't get it out. It's really hard to get out. Why is it so hard to get out? Well, one of the reasons is that the project, it kind of calls for us to get more information. We feel like, well, I got to check this out before I make a decision. I need some more information. And we're too busy this week to do the research. And so it just keeps going off and off in the future. So one of my goals today is to try to help you get up to date in thinking about your estate planning. Now, here's what we're going to cover. Why traditional planning has failed most Americans, why most estate plans don't work, the benefits of our approach. We want to identify the most critical part of estate planning for you that you're interested in. And of course, we want to answer questions and so forth. Now, as we get started, let me mention a couple of things. We probably ought to turn off our phones just so we don't annoy each other. And then the restrooms are right across the hall. And so there's men and women's, it's one at a time, but anyway, they're right across the hall. And then we've got coffee, water, and cookies. So if you need to get up or do something while I'm talking, feel free, that's just fine. In about an hour, I'm going to give you a break for 5 or 10 minutes. We'll refresh ourselves and come back and finish up. So that's sort of the plan for the
Excuse me, the microphone isn't on.
It's not on?
No.
It was.
And it went on?
It just went off.
There you go.
Thank you for telling me. I couldn't tell.
Yeah,
Is it on now?
Tom.
Where my little gizmo is loose. Okay. So, are you ready for an epiphany? Remember what an epiphany is? An epiphany is where you normally think about a thing a certain way. And a lot of times the way we look at things is we try to make them routine and all. But today, since we're talking about estate planning, I want you to think for a minute to make this immediate. Think about this. Hopefully this won't be something that will happen to anybody, don't get me wrong. But let's say we were going home from here. And you're on the feeder road out there on 59, and all of a sudden, you hear this tremendous screeching of brakes. And then there's this enormous impact on your car. And it's all black. You're done. It's over. What would be the state of your affairs in that case? Is your estate planning and your arrangements, is it up to date enough so that it wouldn't create a huge problem for your family? Or think about this. We got two contingencies, right, with your estate planning. One contingency is, okay, we pass away. The other contingency, and in many ways much more difficult, is that we're disabled for a period of time. And as medicine gets better and better, the chances of people live longer and longer just seem better, it seems more and more likely. And that means that it seems like more people are faced with a period of low mobility and dementia. So it's very troublesome. And those are very troublesome and expensive times for families. So imagine this. You went to bed tonight, and in the night, there's this blinding pain in your head and flash. And then in the morning, you see somebody coming in the room, and you think you ought to know who they are, but you're not sure. And when they talk, you're not sure what they're saying. And when you try to talk, nothing comes out. That's the stroke. that's the beginning of, in many cases, a severe disability. Think about your families. Are people named that would be in a position to take over your affairs? Is your spouse prepared or your kids prepared? Have you given this thought on how your affairs would be handled and who's in charge? So that's what we need to think about in this immediate. That's one of the things we need to think about as we're talking about our estate plan. Now, keep in mind another thing is, here's what we do with the estate plan. We say, well, I need to get my will done or my trust done or whatever in order to deal with possible tax and probate and avoid as many of these costs and expenses as possible. But you guys, you know and I know that in life, there's some things, we're all busy all the time. But when you look back over your life, there's some things that stick out that you remember. And those are typically, wedding days and births of children and grandchildren, weddings of children and grandchildren, and the death of loved ones. And when someone passes away, money and taxes and all that stuff come into play, and we need to do what we can about that. But they're also immensely emotional events for families. They have a long hangover after someone passes away. And if things aren't set up right, we can add a whole new dimension of misery for our spouse or kids. So it's got another dimension than just practical stuff. So we think that one of the problems when people are doing their wills is they try to, or their trusts, is they try to just, to keep from thinking about all that, we try to focus on just practical things. And we do need to be practical, but it's got this other dimension. The other thing to keep in mind is, if you have poor estate planning, you get to fall in all these potholes. Okay, so obviously we would like to have our estate plan set up so we don't fall in the potholes. But the other dimension of estate planning is that if you do it well, you can add additional protection for your spouse and your kids. So there's this gain possibility by doing good estate planning. In the bottom, in the end, what we really care about is our family and protecting our spouse and our kids and passing on our values. So we think that these things, your values, your wisdom, your community, and your financial arrangements should be taken care of as much as possible through your estate plan. So if you think about, just to draw an extreme example, if you inherited or acquired Michael Jordan's basketball after he passed away, well, that'd be a good thing. But that's not Michael Jordan. That's not his athleticism. That ball doesn't capture that. Or if you had Shakespeare's pen, I'm sure it would be valuable, and it would be a great thing to have. But that isn't Shakespeare. So you're not just your money either, and just practical considerations. So we believe it's wrong if you focus just on that. You miss some of the opportunity to be a blessing to your family. So what we want you to do as we go through, I'm going to go through a whole different series of events and circumstances. And part of my goal is to let you kind of see into this and think about how that affects your family and your situation and what's important to you. So think about today what we talk about, what's important to you, and I'm going to come back to that at the end. Now, why do most estate plans that are done, where people have estate plans, why don't they work? Well, one reason is that the documents aren't very good, or those documents aren't updated, or where nursing home costs become a problem, there wasn't any planning to deal with that. Or if you have a trust or a will, and the trust doesn't have the property in it, or when you did your will, you didn't think about all the property that isn't going to pass on the under the will, and how it was going to work. Or in your declining years, you lose track of that stuff. Then the will or the trust won't work properly if it's not properly funded in the case of the trust, or your property aligned with what you're trying to do if you set up a will. This one, sometimes people are surprised. No remarriage protection. What am I talking about there? For many estates, one of the concerns and issues that people like to address is, what if my spouse remarries? Is there a way to protect her or him and the family's, the property that should go to the kids? And yes, there is a well-crafted plan, and we'll talk more about that in a minute. And then here's the last one. Most people that have estate planning documents don't have with that anything about the family itself. So just think about it. Right now, you know who your brothers and sisters were, you know about your mother and father and your grandmother and your grandfather, you know where they came from, and you know some of the family history. But your kids don't have a really good handle. So for many families, when mom and dad pass away, that whole thing is just a fuzzy memory. Most families, if you thought about it for a minute, this is something that there are things that you want to pass on to your kids. It was part of your family history, part of your goals in life with your kids, your family traditions. So you want to have a record of that. And your family's going to want to remember where you came from and some of your experiences. We think that should have a place as part of your estate planning. Okay, so to have an example of how some of this works, we're going to talk about Bill and Mary. Bill and Mary live right. I think somebody in the room is named Bill and Mary. This isn't them, those people. This is not personal. But at any rate, this is another Bill and Mary, and they live in Houston. And Bill was a surveyor. First he worked for a pipeline company, and then he worked for a utility here in Houston. And his wife was a teacher in her early years. Then when she had her kids, she was a stay-at-home mom. And now that the kids are gone, she's been involved in volunteering and all kinds of neighborhood and church activities. And Bill is right at the point of retiring. Okay, so now this sounds like Ozzie and Harriet, right? But if you're single or widowed or divorced or married more than once, we're going to cover a lot of situations. So we'll cover all of this. So let me elaborate a little bit on them. So in addition to Bill and Mary, they have their two children, Susan and John. So Susan was a real cute little girl, and she did real good in school. She had nice friends, and she went to Baylor. She became a CPA, and now she's had two little kids herself, and so they're the apple of grandmother Bill and Bob and Mary's eye, of course. Their son grew up in the same household, same idea of trying to teach him good values and discipline and the qualities that we all want in our children. But in high school, he fell in with the wrong crowd, and he experimented with alcohol, and he wasn't very good in school. He did get to go to college, and then he experimented with drugs and alcohol, and he didn't finish college, and then he got married and divorced. And since then, he's held a number of jobs, but he's really not gotten his feet under him. And he still spends too much time with alcohol and drugs. So his parents love him, but they're very worried that he can't get his feet under him. Okay, so Bill is just about to retire. So when you retire, you got to make some lists about what you're going to do. And one of the things you're going to do is that they know they need to update their estate plan. So if you say, well, what could you do? What are your different options if you're thinking about your estate plan? So one of them is to spend every last dollar. Now, at some level, this is appealing to all of us, right? That the idea of the RV with the bumper sticker on the back, and it says, I'm spending my children's inheritance. The problem with it, of course, is that we're not sure when we're going to pass away, and we don't know at what point we need to run out of our money. Now, Willie Nelson, he solved this problem. He said that he wanted to die at least $50,000 in debt. He wasn't just, he's going to go, make sure that he used it all up. And I don't know if y'all remember this, but I think it was in the late 80s or early 90s, the IRS came after Willie Nelson for $30 million. And he said he had truly met his life's goal now. That would have been it. Okay, so anyway, it's not practical because we don't know when we're going to pass away. So another option is not to do anything. Now this sounds kind of risque here, but die intestate means you don't have any will. If somebody doesn't have a will, then every state has rules on where your property is supposed to go. And most of them are very similar. They come out of English law. So and these rules, it's not trying to get it to the state of Texas, although it could end up there eventually. What it's trying to do is get it to your closest living relative. Okay, if you have a traditional marriage like Bill and Mary, and one of them didn't have a will, the intestate rules will leave Bill's property to Mary. So that works okay. If it was a second marriage situation, it would leave Bill's property to his children. Okay, and now the surviving spouse is going to be a partner with the kids, her husband's kids. Very unsatisfactory arrangement. So you don't want to do that. The other thing to say is if you don't have a will, it's going to cost, and you have any probate property, the probate process is going to cost double what it would if you had a decent will. And it's just going to cause all kinds of trouble for your loved ones in going through that process. So it's not a good choice. The short answer is even if you didn't have any probate property, we'll talk more about that in just a second. Even if you didn't have any probate property, you still need a will because you can't be sure you won't have any probate property when you die. So everybody needs a will, at least, okay, as one of their things. And there's other things you also must have. We'll talk about those just as we go through this. Okay. Another thing that's very appealing, I hear this all the time, why can't we just set it up so that in joint tenants with right of survivorship, like our joint checking account at the bank, right? If on the joint checking account, if one spouse passes away, it belongs to the other spouse. And you don't have to go to court. It doesn't matter what your will says. And the reason it works is because when you open the account, you sign the signature card or account application, and it says if one of the co-tenants dies, their interest belongs to the surviving co-tenant. So no lawyers, no will, very easy to transfer title to it. So you say, boy, we want to set everything up like that. Here's the problem. You might guess this. If both of you get run over, bank doesn't know who you have the property to. It turns back into probate property. You need a will. Does that make sense? Right? Just that simple. If one of you passes away, the bank knows who's supposed to get it. Both of you don't know. Okay, so that turns it into probate property. So it's only half a plan because that's got to be one of your scenarios that you cover with your estate planning. Second thing, some property is just about impossible to get into joint tenancy with right of survivorship. The most obvious example in Texas is your house. If you're married and you bought a house and both names are on there, it's not joint tenancy with right of survivorship. If one of the spouses dies, they won't be able to sell the house or refinance it without going to probate court or doing an affidavit of heirship to transfer title. Okay, so there's going to be a court action required or filing action required in order for the surviving spouse to have control of the house. So joint tenancy with right of survivorship just doesn't work in that environment. There are other examples of this, but so that's the problem. You can't get joint tenancy with right of survivorship to work the way you want it to. All right, we can create a simple will. Now, a simple will, typically, everybody says I want a simple will when they say that. But a simple will means that you're married and you pass away, it goes to your spouse. And if he or she doesn't survive, it goes to the kids. And if you're single, it means I leave everything to my kids equally and outright. That's typically what you mean by a simple will. If you do that, number one, this doesn't deal with disability. It only deals with the contingency if I pass away. So we've only got half our stuff covered. The other thing, that simple will doesn't give us a chance to protect our spouse or kids in the way we could if we did better estate planning. So it really leaves a lot of possibilities out. And so when people do that, a lot of times it's just because they're trying to, they don't want to think about it and they want to do whatever's least expensive, just cover the problem. But it might not cover your problem, and that's what we want to look at the situation here and talk about it. Okay, another option is to create a bare bones living trust. You can get a living trust anywhere. You can get one on the internet. You can get one at a stationery store. You can get one from LegalZoom. You can get one from annuity salesmen. They're all over the place. Typically, these are not going to work because either the trust never gets funded or because it doesn't cover the things that would have mattered to your family or some of the things that would have mattered to your family. Or you can plan with us where we'll try to make sure that what you care about gets included in your estate plan. Okay, back to Bill and Mary. So they've been thinking about their estate plan, and what else do you do when you retire? You make up a new to-do list because it's a new part of your life. It's a great time. So Bill and Mary say, okay, the first thing, what we're going to do is put exercise, plan vacations, plan retirement, volunteer. Oh yeah, we got to create a will and plan funeral arrangements. We can get to that later. The reason Bill put exercise on the top of the list is that 6 months before he was going to retire, his boss said, listen, Bill, we're going to bring in this guy and we need you to train him, before you leave. And also, remember, we got all these projects that have been hanging out there so long, and you're the only one who knows how to do it. So, Bill, help us get this done. So Bill has been working furiously for 6 months, and he hadn't had a chance to exercise and take care of himself. So he told Mary, as soon as I retire, let's join the health club and get healthy for the rest of our retirement. So the next day, they go down to the health club and they get on the treadmills and they're going at it, and all of a sudden, Bill faints and falls on the floor, and he's had a stroke on the first day of his retirement. So fortunately, they take him to the hospital, they give him some medicine, and the stroke was transient. There's no damage. And so the next day, he's checked out of the hospital. Stays in overnight, checks out of the hospital. So Bill and Mary, this scared them. And so Bill and Mary said, wait a minute, before we go any further, let's call that attorney that we worked with a few years ago on that real estate issue and see if he can do a simple will. So what they do is they call him up and he says, well, I'm not a estate planning attorney, but I can help you with a simple will. So they go down to his office and they do the simple will, leaving everything to each other and to their kids equally and outright. And they say, okay, we took care of that. And then they go back to their retirement. And 6 months later, Bill has a massive stroke. And this time, he doesn't come home after the next day. And the stroke has damaged his ability to talk. His mental acuity isn't what it was before. He has some difficulty in getting around. But he is able to do most things in taking care of himself. And so Mary is able to take care of him at home. So this is not a nursing home situation. She's going to take care of him at home. It's just he can't talk right. His mental faculties are not quite right. So what I want to do is I want to transition for a second and talk about long-term care expenses. So these are long-term care expenses: in-home care, adult daycare, assisted living, and nursing home costs. So how do you pay for these? 5 ways. One way, you can pay out of your own pocket, obviously. Another is that you can buy long-term care insurance. And so that people that have long-term care insurance and then need it are happy that they have it. People who have long-term care insurance and not sure they're going to need it are less happy. The reason they're less happy is they're retired and the insurance company keeps raising the premiums, so it makes it hard to handle when you're retired. Also, if you never need nursing home care, it's a great weight on the retired couple to be paying these fees all the time and not being sure that it's ever going to pay off. Finally, the number of insurance companies that handle these things is shrinking like crazy because they prove to be very unprofitable for the insurance companies. So there's no use to providing. So at any rate, the combination means that a relatively small number of people out of the population actually have a long-term care insurance. The other program that people over 65 in the United States typically all have is Medicare. Medicare covers doctors and hospitals, but it only covers long-term care just enough to confuse everybody, okay? And so let me explain how this confuses everybody. And this confusion is rampant, especially by people under 65, because a lot of times kids, the children of folks who are 65 and older, they think once mom and dad have Medicare, it'll cover all this stuff. Well, the way it works is Medicare covers doctors and hospitals. Okay? So if someone has goes to the hospital and has a procedure, the doctor and the hospital, that's covered by Medicare. And the rehab connected with that is covered by Medicare. Okay? So in the typical case with the older person, where this is a big issue, would be the person falls down and breaks their hip or has a stroke or a heart attack, they go to the hospital for a few days, then they go to rehab in a nursing home. Medicare covers, typically it's 20 days or less. It can be up to 100 days, but it's only whatever the doctor says the period of rehab is. And that rehab, if as soon as it either ends or the person fails to make progress, it ends. When it ends, if the person can't go back home, they need to stay in the nursing home for care, then it's private pay at that point. So for many families, this is a real jarring situation. Here they've been worried about mom or dad being able to take care of themselves. Now they've had a stroke. Now they're in the hospital. Now they're in rehab. And they're trying to figure out how to deal with all this stuff. And the next thing that the nursing home says is, oh, by the way, this is private pay and it's going to be $7,000 a month starting now or starting next week. So it's a real stressful shocker for people. Now, this is the program that covers Medicaid. As a matter of fact, if people are in the nursing home very long, the huge percentage are on Medicaid. This program, everybody doesn't have. You have to qualify for it. And at first blush, you have to be flat broke to qualify for Medicaid, because the basic rule is for a single individual, you have to have less than $2,000 in countable resources. Okay? $2,000 in the bank, less than $2,000 in the bank. And your income, monthly income, Social Security, pension, and so forth, has to be under about $2,300 to qualify. So, first blush, you have to be flat broke to qualify. In fact, the rules are much more complicated than that. And for married couples, they're more lenient. And so, but they're also more complicated. So, many middle-class people can qualify for Medicaid, but you got to qualify for it in order for it to go into effect. We're going to talk more about that. I'll give you an example in a minute. Okay, the other program that is helpful, let me mention one other thing. Medicaid will not pay for assisted living. Okay, Medicaid pays for nursing home care. In order to qualify, the person must meet medical necessity. That means they need to have assistance with 2 of the activities of daily living, and that they need medical supervision. Okay, if they don't meet those requirements, they're not going to get Medicaid. So what about if the person needs extra money for assisted living or in-home care, and they can't qualify for Medicaid? Well, in some cases, those people can qualify for aid for veterans benefits. So how does this work? Who can qualify? It's any person who's served on active duty during a wartime period since World War II. Well, it turns out the wartime period since World War II is just about all the time since World War II. So really the issue is, did the person serve on active duty during this period? If they did, and they're over 65, and they can show the VA that the amount of money they have right now isn't enough to cover this extra increment required for home health care or for assisted living, then they can get aid and attendance. The award is typically in the $1,000 to $2,000 a month, so it can be very helpful in assisted living and some other situation for the veteran. The veteran cannot have, the general rule was, I'm not sure if they've changed it all, that the person couldn't have more than about $80,000 in assets to qualify. Let me see, there was something else I was going to tell you about that. Oh, the spouse of a veteran can qualify. So the surviving spouse of a veteran can qualify, and the pension is slightly less, but it's the same idea. In order to go through this process, you go to a Veterans Affairs office in the county. They'll help you do the application. It disappears into VA. You can't figure out what's going on, and then with luck, months later, it gets approved, and then it's retroactively goes back. They'll get a lump sum, and then it'll go forward from there. Yes, sir?
What if you're already a disabled veteran?
So, if you're already a disabled veteran, you may still be able to qualify for additional sums. I think that's...
I didn't know if they had a limitation about assets if you were already disabled.
it's different program. I'm not sorry. I kind of think it would be. You'd still be under those asset rules. Okay, so here are the ways that you can pay for long-term care insurance, right? We said you can use your own money, buy long-term care insurance, apply for the Medicare benefits, become eligible for Medicaid or the aid and attendance. Okay, so now I'm going to digress a little bit, and we're going to talk about this disability problem. And so here we have Ralph and Ruth. And Ralph and Ruth live right down the street from Bob and Mary. And as a matter of fact, they have known each other because they both couples moved into the neighborhood at about the same time. And their kids were about the same age. So they were always, connected with each other through the children and their proximity as neighbors. And so we have Ralph and Ruth, and we have their kids, Rachel and Ryan, and of course the dog. So Ralph retired a few years ago. And when he retired, his nest egg wasn't as big as Bill and Mary's. I didn't really go into that. We'll go into that in a minute. But anyway, his nest egg was about $250,000. And then he had Social Security. So he retired. And at the time he retired, Ruth, she was having a little bit of trouble remembering words when she would be talking. And so everybody just, just kind of laughed it off. But this problem went faster and faster. And what happened to her is she had that early onset dementia, the early onset Alzheimer's or dementia. And of course, usually we associate this with somebody who's in their 80s and 90s and way up in years. But you may have been affected in your family. I've had a couple different acquaintances of mine that have had this affect their family at a very young age, typically in the 60s, somewhere in the 60s. So that's what happened to Ruth. She got this dementia. And of course, Ralph is going to take care of her at home. Except as her dementia progressed fairly rapidly, the problem is that here we have someone who is losing their marbles, but looks just fine, okay? And so they drive to the supermarket and they can't find their car. They go to the supermarket and they can't find their keys. And then they walk down the street and around the corner and they can't get back home. And so this is really distressing. The other thing that happens is sometimes people's personality changes and they may become very anxious and irritated. And so in their case, Ralph just worked himself to death trying to take care of her, and he felt very much like she was at risk because she would, in the middle of the night, get up and go outside. And so he just felt like he couldn't take care of her. So what he did is he went to a nearby nursing home that had a memory care unit where they could keep track of her, and he paid for her care there. And so this went on for 37 months. And during that period of time, this is a lower amount, but the cost with that calculation was close to $200,000. And in the process, essentially, he spent his nest egg. And they had some credit card debt. And so as his nest egg went down, his credit cards and costs went up with taking care of his wife. Finally, he declared bankruptcy. And so at the end of the day, his wife has passed away. His retirement nest egg is gone. And he's left with the home and Social Security. So what a bleak occurrence for this family. And so that's a terrible sequence of events to have happen. Now, he did something that was a mistake. The mistake was he didn't come talk to us. So in our law firm, we help people, some people call it elder law, but it's an effort to help people deal with these long-term care expenses and specifically to qualify for Medicaid. If he'd come to see us, we would have been able to save a big part of that $250,000 for the family, not have to spend it. He would have we would have worked out a strategy with him to qualify his wife for Medicaid, and he would have known, okay, the bleeding is going to stop here because we're going to be able to put the application in here, and after that, the Medicaid will pick up the bill on this. So by not talking to us earlier in this process, he missed this huge opportunity, and he just added to his own misery. And we see this, this is of course a scenario here for you, but we see this as a fact in our practice. Many, many times the family has spent tens of thousands of dollars at the nursing home. If they come to see us earlier, they could have saved a good bit of that money, a lot of that money, and taken a lot of the worry out of this whole process. So this is an important service that we're able to provide for clients. Okay, let's go back to Bill. Remember, Mary doesn't have the long-term care in the nursing home problem because she's taking care of Bill at home. So what's her problem? Remember, they have a simple will. So what's the problem? Well, she needs to take a distribution out of Bill's IRA. Now, I hope you all realize, you probably know this, but let me just emphasize it. Your individual retirement account is only in one person's name. It's either the husband's name or the wife's name. There's no such thing as an IRA with two people's names on it. No such thing as an IRA inside of a trust. An IRA only has one person's name on it, okay? And Bill's name is on this IRA. So Mary calls up the financial institution, and she knows that she's the primary beneficiary after Bill dies. So she figured, well, I'm sure they'll talk to me then. So she calls them up, and she says, I need to take a distribution out of my husband's IRA. Here's his account number. And the person on the other end of the phone says, you need to put your husband on the phone. And she says, well, he can't come to the phone because he can't talk right. He had a stroke. And after a pause, the person on the other end of the phone says, have you got power of attorney? If she does not have power of attorney, she is not going to get into that account. Okay? So, the will is no help in this case, right? That simple will is not enough by itself. So in order to deal with this disability thing, in the first, everybody needs this. You need this whether you have a trust, you need whether you have a will. It doesn't matter. Everybody needs one of these things. You need a power of attorney. Now, a lot of times they're called statutory durable powers of attorney, which makes you think they're all the same. Well, they're not all the same, and you'd do well to get one from an outfit that had experience with this whole process. We see over and over again where families have no power of attorney or the power of attorney is inadequate to do whatever it is we need to qualify for Medicaid, for example, or whatever it is we're trying to do. So this power of attorney is extremely important, very routine document. Everybody needs to have one. Typically, you're going to name your spouse as the primary agent for you. You're the principal, you're going to name an agent, and then maybe you name your kids as the alternate agent if your spouse wasn't able to do it. So this is a key document everybody needs. So if she doesn't have it, what do? Well, either you don't do anything with that asset, or if you've got to, guess what? You get to go to court. She has to get herself declared as his guardian. This means that we're going to have to go before the court. We've got to submit an application. We've got to have extensive report from the doctor about the nature of his disability and what he can and cannot decide. It's just a big drill. And so this process typically takes about 4 months or longer, and it costs several $1,000s. And at the end of the deal, Mary gets appointed as guardian, and then she has to report to the court every year on how much income came through the household and where it went. Are we having fun yet? Not good, okay? So we don't want to do that. Make sure you got a power of attorney or trust for both. I mean, both. Okay. Not a good plan. Okay. After 3 years, let's say, Bill passes away. Remember the home? Home's in both their names, right? Community property, half owned by each spouse. So, if Bill dies, she has to probate that will. Now, there's a lot of misunderstanding about this, so I want to help you see how this works. Let's say that for my wife and I usually talk about my wife. My wife and I have been married for 50 years this year. So she is the blessing of my life, right? Through all this Army career and everything else. So we've been married for it'll be 50 years this year. And we have 2 children in their 30s, and they're both married. My son and daughter are both married, and both of them have little kids. So my daughter has 3 little boys. Oldest is 10. They're 10, 7, and 5. And my son has 4 kids, 7, 5, 3, and 1. So they're kind of busy. But anyway, we're very blessed to be part of the community and have those children. Okay, so let's talk about, so anyway, I was going to tell you, my wife handles all the finances, right? So she knows where everything is. So, and we got the trust and all that, so she's got control over it if something happens to me too. So I say to myself, Bob, I think I need to have a secret fishing account, right? So I go over to the bank and I open up my secret fishing account, and I have them send the stuff to the law firm, so I keep it at my desk. So if I get run over, my wife goes to the office and she's looking around in there and she finds this checkbook. It's got a couple of $1,000 in it. I'm like, what the heck is that? And of course, I just kept it to buy presents for her and stuff, right? But anyway, so my wife goes over to the bank and she says, my husband died, here's the death certificate, and I found out he has this account, I need to close it out. And the cashier looks at whatever they look at to see whose signature is on that signature card, and she says, well, ma'am, I'd like to help you, but you're not on the signature card, and since he's passed away, you're going to need letters testamentary. So my wife says, wait a minute, that's got to do with the will, right? I got the will right here. So she whips the will out, and this will it's initialed on every page. It's signed by me in 2 places at least, and it's got witnesses and notary and all that stuff. It's just as official as it can be. And in big print on the second page, it says the executor of my estate is her. And she says, here's my driver's license, here's the will, so how about doing what I said? And the cashier says, well, ma'am, I'm sorry, I'll let you talk to the manager, but you're going to need letters testamentary. Well, why would she need letters testamentary from a judge? It's like you went to all this trouble to get this will done. What is the deal? The deal is that the bank doesn't know whether that's an out-and-out forgery. They don't know if she's my first wife making an end run on my second wife. They are not going there, okay? They want a judge to give a letter saying that she's authorized to round up my stuff. That letter's testamentary. That's the probate process. So the fact that you have a perfectly beautiful will won't get you anywhere until you go and get the letter from the judge. That's the basic probate process. Everybody clear on that? Okay? So a lot of people think, well, once I have the will, I don't have to go to probate. Wrong. If you got probate property, you're going to go to court, and it's a good thing you have a will, but you still have that problem. So you say, well, how much does it cost to go to probate court, and what's involved in that? In my office, we do lots of probates. It's about $3,500 if you have a good will. There's no problems. About $3,500, and it's going to take about 8 weeks from the time we do the application until we get the letters testamentary. Okay? So that's what you're looking at. It's not the end of the world, but you can't really do anything to round up the property until you get letters testamentary. So the work of, when you settle a estate, a lot of times there's lots of loose ends and accounts and real estate and no telling what all. You can't do anything with a lot of that until you get letters testamentary. So it's like, okay, we got to pause, wait, we can't access these accounts until we get this, and then I can go to work. So it's just an aggravation, and that's what it involves. And of course that could happen for each spouse, so you can get 2 of those probates. Does that make sense? Everybody okay?
So how do you avoid that? How do you avoid that?
Well, with a trust,
Oh, that's right.
it's one way to avoid probate. Now, some property doesn't pass through probate. Remember we were talking about that joint account with right of survivorship? Doesn't pass through probate. Doesn't matter what your will said. It's not governed by the will. And your IRA and 401k and life insurance that have a beneficiary designation on them, doesn't matter what your will says, that goes according to the beneficiary designation. So this is part of the problem, that you have a bunch of different assets. Some are going by beneficiary designation. Some of them are going by joint tenants with right of survivorship, one passes away. And then some stuff goes through the probate process. Typically, there's going to be more probate property on the second death, because on the first death, a lot of stuff just goes by joint tenancy and beneficiary designation to the survivor. But then the survivor has more accounts in their own name, typically. And so there's liable to be more probate action. More things that are part of the probate process. More accounts that are probate property.
How do you get a list of what has to be probated and what doesn't?
Well, what I just said is a good list. 3 kinds of property that you have. Joint accounts with right of survivorship, like your joint checking account. beneficiary designations like IRAs and 401ks and life insurance, and you already know that they have a beneficiary designation. If you name a person, it doesn't fall under the will. If you have an account just in your name, the bank doesn't know who to give it to when you pass away. Okay? So that's probate property. Anytime they don't know who to give it to in their own records, it's going to be probate property. All right, so bill passes away, we get to go to probate court. Now, you'd think that the process would be to help the surviving spouse. Well, in a way it is, but the probate process really is to resolve disputes, pay the creditors of the estate, inventory, you have to submit an inventory and appraisement of the property that's in the estate. You got to notify creditors, and then you change the title, the executor changes the title on the assets and distributes them according to the will. So this is the probate process. And I already told you about the cost there and about the time. Now, notice this, multiple probates. Are we having fun yet? If you have property in another state, let's say you have mineral interests in Oklahoma, or you've got a condo in Colorado, or you've got a timeshare in Branson, that stuff that's in another state, you're going to have to probate in Texas, and then you're going to have some kind of probate-like thing in the other state. That is way too much trouble for you and your family. What you want to do is have a trust in that case and put the property that's out of state in the trust and all your in-state probate property in the trust and skip the probates everywhere. It's just too much hassle to mess with all that stuff. Okay, so that's one of the big indicators an obvious indicator that it would be sensible to have a trust. Okay, now the good news, right, there's always a little good news. This is actually pretty good news. Although maybe it no longer matters to most of us. But they doubled the estate tax exemption in 2018. It went from around 5.5 million to 11 million. And this year it's 11.4 million per person. So if a married couple can leave $22.8 million to their kids this year with no estate tax. So now if you have to pay estate tax, you are blessed indeed, right? And the rest of us can just ignore that whole problem, okay? So when I started practice back in the 90s, and you guys probably remember this, the estate tax exemption was $600,000. And regular, or every middle-class person that had an insurance policy and a retirement plan either had more than $600,000 or was likely to have more than $600,000. And the other part of the tax law was that unless you had special tax planning in your trust or will, you'd only get one of your two exemptions if you left everything to your spouse. So you had this special planning if you wanted to make sure that two spouses were each going to get their exemption. And I bet you somebody in this room has got a will or a trust with that tax planning in it. It's so old, right? Now, nowadays you can do without the tax planning. You still might want to set up some planning, special planning that includes creating a trust for your spouse, but you don't need it for estate tax for most people. Now, for clients that have an estate between 11 million and 22 million, there is a dilemma. The dilemma is that in 2025, the estate tax sunsets, and it goes from 11 million back to what it would have been under the old law, about 6 million by then, or somewhere around 6 million per person. So for somebody that has an estate in the middle there someplace, then this is still a potential worry that the estate tax would come to play. State death tax. Okay, Texas doesn't have a death tax, so rejoice and be glad. That's not an issue here. However, if you inherit property in the upper Midwest or East Coast or West Coast, some states have their own estate tax, and it's got nothing to do with 11 million. And so I've had clients that inherited property in Illinois, farmland in Illinois, and the executor had to pay Illinois estate tax. So sometimes families can get involved in the estate tax. Okay, there's another rule that's, it used to be real interesting, but now it's not very interesting anymore. There's an unlimited marital deduction. You can leave any amount to your spouse unless they're not a citizen of the United States. But if your wife is a citizen, you can leave any amount. So Bill Gates can leave his billions to Melinda, and there's no tax at that level. It's after both of them pass away that the government collects the estate tax. Okay, Now, so Bill has gone, we've had a disability problem where Mary had to get the guardianship, and then he passed away, so we had the probate process. Remember, that simple will doesn't say anything about where Bill was born, or what he knew, the jokes he used to tell, the family events they were involved with. That's wasn't part of the deal, okay? So maybe the family's got some records, maybe not. Seems like that would have been something they wanted to capture. So, summary of a bad estate planning so far. Guardianship problem, there wasn't any protection from nursing home expenses, no protection from probate when he passed away, and they didn't keep track of his life experiences and information about him and the family. At least not as part of their estate planning. Okay, the story's not over. Okay, that's another thing you need to think about your estate planning. It's not just from this spouse to that spouse, or from this person to your kids. We got all this sequence of events going on. So now Mary is a widow. Okay, so what might we worry about? Well, we might worry that she's going to remarry. That's late season marriages are an estate planning problem typically. Lawsuits and creditor claims. There's no protection from from the estate that Bill left her. And nothing was set up that would provide any protection from nursing home costs for her. Now, after Bill passes away, remember Ralph? Ralph lives right down the street. His wife passed away, and so he comes down to console Mary. And so, they have a lot to share. And then, they're both kind of lonely, and so they go for walks, they go out get some coffee, they go out to lunch, they go to the movies in the afternoon. And after a few months, they have developed a wonderful relationship. And let's say Ralph proposes. Okay, so is this going to have? Could this have a bad effect on Bill's estate plan? Right? Now, most families, we may have to say something more about this later, but in most families, somebody in your family knows of an event where granddad remarried and the farm went down the new wife's side of the family, right? That is a significant problem on remarriages. Now, here's what people don't realize, or frequently don't realize, that Bill and Mary could have built in things that would ensure that Bill's half went to his kids, okay? And they could have built in things that protected Mary's half from any claims of the new spouse, okay? They could have done that. I think we're going to talk more about that in a minute. They also, when they set up their estate plan, instead of that simple will, they could have set up an arrangement where Bill's half of the property wasn't considered an available asset if Mary went into a nursing home. In other words, Bill's half of the estate would not have had to have been spent in order to qualify Mary for Medicaid. Okay? So that wasn't part of the plan. Now also, it says, are the family's assets at risk if Mary gets sued? Now for a lot of retirees, we think, well, I'm not really in a place where I'm going to cause any trouble and get sued. However, things happen. Just to give you a real life example, I had this really nice couple, and I started working with them in the early 2000s. The wife died a few years later. The husband named his son as co-trustee with him as he was getting older. And I would see him every year because he would come to our office to do his tax returns. So we would chat and talk. In 2017, he got lost coming to my office. And we finally got started now, but then around a little after Thanksgiving that year, his son called and said that he had been in this terrible accident and that he was in intensive care. And he said there were 7 cars involved in this accident, and I think my dad caused it. Well, that's going to run above his insurance liability limit. So there's an example of someone who wasn't expecting to be sued, but likely would be, and it could be very risky. So you can establish asset protection in your estate plan that would provide protection for the surviving spouse from lawsuits. Okay, so let's talk about Mary's situation. Mary, I meant to say this at the start. In our planning, Bill and Mary retired. They had a $700,000 estate. So we're going to imagine that after Bill passed away, she still got $700,000. So then the question is, well, let me see what the next slide is. First thing to say is, so I've been married. A lot of us in this room probably have been married a long time. So the first thing that you say or think, or you're supposed to think, is, if I passed away, my wife would just pass away the next week, right? Have a broken heart. And so in a real sense, I mean, that's kind of funny, but in a real sense, it's just like we can't imagine that one of us is going to proceed into the misty future. And you can't bring up to your spouse, oh, I hope you you can't really talk about remarriage of the surviving spouse. It's not a comfortable discussion. However, for our purposes, we need to discuss it. So let me tell you this. The statistics that we have are that a surviving spouse lives on an average of 7 years after the death of the spouse, more or less 7 years. A lot of water can go under the bridge in 7 years. And this is, from a estate standpoint, this is one of the most dangerous periods. Why is that? Well, just summon your own memory of this. When people are in the last stage of life, it's very likely the last year or 2 or 3, they're going to be running on slow speed. People that were meticulous before lose that meticulousness. Yeah, thank you. I'm at least warm. People that were meticulous before lose that meticulous. Estates get all messed up during that period. People lose track of stuff. And also, there's a high probability, oftentimes people have caregivers, or they find a new partner, or they remarry. And this causes nothing but mayhem in estate planning in the States, very typically. So this is a very concerning period if you're thinking about your estate plan. And to be realistic about it, you've got to realize that one spouse is likely to survive the other. Also, keep in mind, while the couple are together, if something happens to me, my wife will probably take care of me until, as much as she can at home. But after I pass away, it's going to be harder for our kids to take care of her if she becomes disabled. So it's much more likely the surviving spouse is going to need nursing home care or need more attention from other family members other than the spouses. So the risk shifts during that period. Okay, so we're going to imagine in our case that she in fact lived 10 years. Now, the other thing to say is that when people retire, they worry about running out of money. But in fact, I've been watching this for all 25 years. Some people do run out of money. Some estates stay pretty flat, and some grow during that period. So we're going to imagine in our case that Mary's estate grew during this period and doubled because her home was in a very desirable area and it shot up, and she had good luck with her investments. So her estate doubled to $1.4 million. Now, after 8 or so years, she got to where she was having a hard time managing. Her daughter was real worried about her, and they needed felt like she couldn't take care of herself at home. So, and then she had a stroke, so it ended up that she needed nursing home care. So, if she only has a will still, what's the problem? The will doesn't go into effect when you're disabled. It doesn't empower her daughter or son or anybody else to take care of her while she's disabled. So she should have had a power of attorney, and she should have named her daughter to be the one to handle it. But she didn't have that, so guess what? We've got the responsible CPA daughter and the irresponsible son. Now I ask you, who do you think is going to be most anxious to manage Mom's $1.4 million estate? The shiftless son or the CPA daughter? The son's going to fall over himself to get hold of this, right? So this is another area of conflict and trouble and lack of continuity that occurs in families if we don't take care of this stuff. So then Mary passes away, so she's got that simple will still. We get to go to probate court and sort that out. Let's see, I really didn't finish this thought. Back here, if she didn't leave them with the power of attorney, and they got to get control of this, they'd have to go back to probate court and one of them appointed as guardian. And you can have a big fight about who's going to be the guardian. It's just another chance to waste money and create conflict in the family because of poor planning. So then Mary passes away. We get to go through probate again. And again, maybe somebody had records elsewhere, but it wasn't a conscious part of the estate plan to have anything about Mary. And Mary may have known a lot about Bill and the details of his life, but now they're both gone. Will the kids be able to recall that? Is there a record, right? Or is this just a fading memory of Bill and Mary? We'd like to leave something behind ourselves that our kids can remember. So this is a bad show. In our case, in our example, we've tried to show how you could fall in all these pitfalls and not make plans to protect the spouses. So the story's still not over. Okay, now let's imagine that this 1.4, they had to spend about $100,000 in the nursing home here, let's say. So the state's worth $1.3 million. So the will says equally and outright. So this means the son is going to get $650,000, and the daughter is going to get $650,000. So Financial Planning Magazine says clients' biggest concern for their wealth after they're gone is that someone will take financial advantage of their children or grandchildren. Well, that's true, but kind of blah. Here's what my clients say. They say, what if my kids get divorced and the family assets go to my no-good son-in-law or daughter-in-law? That's what they say. Or they say, my kids aren't really good with this stuff. What if they can't hold on to it? What if they lose there's our life savings delivered to them, and now they don't know. We're worried that they have sense enough to manage this stuff. And then the kids are already in trouble. They've already got tax problems. They've already got debt or other financial difficulties, and now we drop this money on them, and some of it's immediately going to evaporate because of existing problems. What a miserable situation. So that's what's the worry is. And so I should mention, remember I told you Susan was the perfect little girl, right? She did everything right. She was a joy to her parents, Baylor, accounting degree, CPA, great kid. She only did one thing. Wrong. She married Jason. This is her husband, right? And so he is kind of shiftless. He's interested in the get-rich-quick schemes, but he's not too eager to work day to day. Susan has a great job as a CPA in an accounting firm, but the marriage has never been that great. Bill and Mary were always worried that it might break up, but it hadn't broken up at the time they passed away, but it could break up in the future at some point. If that $650,000 gets delivered to the daughter, it's separate property under Texas law, which means it's not community property, which means in a divorce, you think, only the community property is going to get split, not the separate property. It won't work. It will not work. If this money goes into her accounts, if they have a divorce and there's a settlement, if they have a divorce, there's going to be a fight about what part of this separate property is actually community property. And the end is there's going to be a settlement, and some of this inheritance is going to go to the no-good Jason. Okay, so for families, this just makes your blood boil. So there's a better way to do this, and I'll talk about it in just a minute. All right, the son that's irresponsible, right? He's had drug problems, drinking problems, DWIs. He's kind of casual about paying his taxes, so the IRS is after him. And so now he gets $650,000. What is the prospect that money is going to last? This is half of his parents' life savings. Kablam! Here it goes. And of course, in the background, you'll see this is a genetic thing. I want to point out for young males who inherit money, the first expenditure is to buy a fast-red car, right? It's a genetic thing, a genetic problem. And how is this going to go with somebody that drinks? If the money goes into an account under his Social Security number and he's already in collection from the IRS, they will snatch it. Okay? So this has got no chance of being a blessing for the son that Bill and Mary loved. Right? What a shame. Couldn't we do something better? So this has not worked well for this family in our example. So there's got to be a better alternative. So what we need to do is take a break and come back, and we'll see if we can't do this better in a minute, okay? So we're going to need to find a better alternative. So what might that be? Well, we're going to talk about living trust. Everybody's heard of living trust. We're just not sure how much trouble it might mean to us, or whether we're going to lose control or whatever. So we're going to talk about that. Now, in those famous, that video I ran at the start is called Famous Estates, or it could be called Famous Estates that are really fouled up. But Bing Crosby wasn't in Famous Estates because Bing Crosby had a trust, right? So it wasn't public in the way that wills create a public spectacle for celebrities and can create public access to anybody's probate records. When Frank Sinatra died, all the reporters rush, after some celebrity dies, and one of the things they want to know is when's the will going to be offered for probate? Because as soon as that will goes into the probate court, they can get a copy of it and they can see what the family's distribution stuff is. And then later there's going to be an inventory and they can tell what's in the estate. So for some people, that public quality is extremely disturbing. As a matter of fact, I had a client, and she was in a smaller town outside of Houston, and she was a big deal in this town. And so she had lawyers and all kinds of stuff and all kinds of connections. And she came to me to do a estate plan because she wanted a trust. And she wanted a trust because she couldn't stand the thought that all her sweet neighbors could go down to the courthouse and find out all about the family after she passed away. So that was an example in her case. So what we're going to do is we're going to give Bill and Mary a do-over. Remember when you were a little kid, if you messed up, you got a do-over? So we're going to give them a do-over. And so this time when they set up their to-do list, they're going to create a living trust on this thing. Now, I already talked to you about this. You can get a trust anywhere. And just having some pages that you filled in the blank on is not going to give you much peace of mind about this. It may not cover the things you care about, and unless it's properly funded, it's not going to work the way you intend. So we need to do better than that. We think that what you want to do is you want to deal with what you're trying to do. Life is uncertain. Things could come up that your estate plan didn't anticipate. But what you really want is for your estate plan to anticipate as many routine problems as possible and keep you out of it, keep you and your family out of it as much as possible. And then the other thing is that there's a chance to bless and protect your kids or your spouse by creating helpful protections. Well, then we don't like to do that as well. And then we need to, for most families, I think this has a lot of resonance. There ought to be a place where we're keeping some record of our own lives and our immediate family that's part of the reservoir of information we want to pass on to our children. And so part of that, or the index to it, or some of that information should be part of your estate plan. Now, it turns out, think about this, what was causing the problem for Mary and Bill and for them? The problem was that when stuff was in Bill's name and something happened to Bill, Mary couldn't access it without going to court. Okay, so it turns out that the living trust offers us a way to set things up so that in the event we're disabled or we pass away, it makes it easier for our spouse or our kids to take care of things, or our beneficiaries to take care of things. So the magic turns out to be in how it's titled. And so you say, well, okay, I've heard about these living trusts, but I'm not sure, am I going to lose control? How much trouble is this? Is it going to create tax problems? How does it work? So the idea is that you're going to create this legal box, so to speak, your treasure chest, and you're going to put your property into it. You're going to convey your property to it. Now, so you're going to put your probate property in there. We recommend that you put, typically that you put your after-tax investment accounts and checking accounts and so forth in there. All real estate, mineral interest, timeshares, all that kind of stuff that would be a potential problem if a person passed away. IRAs and 401ks are not going to be in it. Remember, if you own an IRA, your name has to stay on it as long as you're alive, unless you want to pay all the income tax on it. So the IRA is in its own wrapper. If you're married, you want the primary beneficiary to be your spouse, and the contingent beneficiary to be your kids, unless you're creating a trust for your kids. In that case, you want the primary beneficiary to be your wife still, or your spouse, and you want the contingent beneficiary to be the trust you're creating for your kids. So we'll get more on that in a second. But anyway, we want to get our property in there. We're especially trying to make sure that the probate property is in the trust, and we're going to make sure that everything works the way you want it to work. And so if you're thinking about your estate planning, doing the necessary documents or updating the documents you have is part of the problem. The other part is to make sure your stuff is going to flow the way your plan is designed to work. So we got to get both those things together if we're going to do this right. Now, a trust has 3 different parties involved. Okay, so this confuses people, this legal language, but it's not very scary in fact. So the trust has the people who create the trust. They're called trustors or trust makers or grantors, and that's whoever sets it up. And the trustee manages the property, has the checkbook, and decides what the beneficiary gets. And the beneficiaries receive the benefit of the trust. So you say, well, that sounds like I'm losing control of this stuff. Well, not exactly, because guess what? If you set these up the way they're typically set up, Bill and Mary are the creators of the trust, and since they're creating it, it's created as a revocable and amendable. So they're not locked into this, they can change it. Second thing is, they're the trustees. So they have the checkbook, they decide how the money's invested. And as long as either one of them is alive, they're the beneficiary. So there's no strangers here. The fact that you created this trust doesn't give anybody else access or control of your property. It doesn't throw it into the hands of someone else. It's just between, if you're married, you and your spouse, as long as you're alive. If you're single, then you're going to set up the trust, and it's all for you during your life, and then after you're gone, it can go to your kids or other beneficiaries.
Who does that trust go to then in the case of an accident where both of the owners are deceased?
It goes to whoever you want it to go to. You know, for most families, that'd be to your kids at that point. Yeah, so the trust is going to deal with all these circumstances. We'll talk about that in just a minute. And that's one of the things. It's not just if dealing only with one spouse passes away. We've got all these contingencies. I have a slide on it in just a sec. Okay, so are Bill and Mary, say this once again, do they have control? Yes. They can still buy and sell and refinance assets. It will not create a tax return for them, an extra tax return. Normally, when you set up an LLC or a corporation or an irrevocable trust, you have to go to the IRS and get a tax ID number, and then as a booby prize, you get to file an extra tax return for just whatever it is you just created. That is not the case with these living trusts. The IRS rule is if you have control of the trust, complete control of the trust, as you do in this case, and you use your Social Security number on the accounts that are set up in the name of the trust, there's no extra tax return, and everything's going to be taxed just the way it was before you set up the trust. So there's no tax implication there. For married couples, it could have either, some accounts could be under one spouse's Social Security number, and some could be under the other. Both would be on the account registration. But typically, an account only uses one of the Social Security numbers for tax purposes. Okay, another big worry is, wait a minute, I got a house. If I transfer it in the trust, am I going to lose my homestead exemption? Am I going to lose my over 65 exemption? What if I have a mortgage on it? Is that a problem in setting up this trust? Answer, no. Okay, you can still qualify for your homestead exemption. You can qualify for your over 65 exemption, even though the property is in the trust. And whether you have a mortgage or not, we can still transfer the property to the trust. Okay? Not a problem. Okay, so why did I do this? I went to this trouble to set up this trust, create these provisions, and now I've gone to the trouble of retightening the accounts and making sure everything's set up right. It's a standby device in case one of us becomes disabled, or both for that matter, or if one passes away. So it's we've got two contingencies. What if we become disabled? What if we pass away? That's why we set up this trust. Now, if you think about it, it's like you're doing the funding work on the front end. Whereas if you don't do this planning and you just had a will, the transferring of assets to the spouse occur through a court process for any probate property, or through a probate process to get it to your children if you have probate property. Whereas here you're going to put the property in the trust, and then your family doesn't have to deal with that transfer at each stage, and it doesn't have to go to court. Unless they left something out of the trust, it's probate property. Okay, so you're talking about this idea of how does it deal over time. This is another reason why the trust needs to be, you need to think about your estate planning and think about your situation, because the trust and your estate plan need to cover a long period of time. When we set up our estate planning, we're hoping we're going to live a long time, so there's that time, and then it's going to our kids. And so let's just talk about this. We got this document, right? This trust document, and it's thicker than your will. And you say, well, why is that thing so thick? Well, one reason is that it's got to cover the situation when both spouses are alive, right? Then it's got to cover the situation if one spouse is disabled and the other spouse is in charge. And then it's got to cover the situation if one passes away. And then it's got to cover the situation if the surviving spouse is in charge of this thing. And then it's going to cover the situation if the surviving spouse becomes disabled. And then if the surviving spouse passes away. And then it's going to deliver the property to your kids with whatever additional features you'd like to have for their plan. So this thing could last for generations. So we want to spend the time to get it right and have the hope that it's going to work for us. Okay, so just to go through the sequence. Remember, Bill had the stroke, and Mary couldn't get into the IRA because she didn't have power of attorney in that case. So she had to go to court. Well, not this time, because she's got power of attorney in the trust. She's going to have all the documents she needs, and so she's not going to go to court, and she'll have control of the property. When he passes away, since the house is in the trust and other probate property, she doesn't have to go to court. So she's in charge from day one, and also she's not under the risk that accounts will be frozen for some period of time after one spouse passes away. So you have a convenience factor and better control for the surviving spouse and for your kids if you set it up so it's a lot of times it's very disconcerting if an account is frozen for a period of time right after somebody passes away, as you can imagine. Okay, so in this case, we're not going to probate court because the probate property's in the trust. And then in our planning, there would be a place to remember important information about Bill, so that's not lost. And what about taxes? The tax rules, those estate tax rules, are essentially the same for the trust as it is for you. However, and of course most of us don't care, but for people who are pushing these limits, you can get an extra tax advantage by using trust-based planning. So there is a potential for an additional advantage there. And this time around, what about Ralph? Okay, this time, if they marry, how would you protect Bill? You know, if he's passed away, but surely he wants his property to go to his kids, and presumably Mary wants it to go to her kids. But a lot of times, the surviving spouse, this all gets confused and goes the wrong way. So what could we do? We could what we can do is that when Bill passes away with trust, he can create a special trust for his spouse that holds his half of the property. Okay? If he does that, then we can put in provisions that say, if Mary remarries, she has to get a premarital agreement. Now this trust and that provision do two things. First, legally the property that's in that trust, it's for Mary, or if she's not there, it's for the kids, his kids. That's the only place that trust can legally go. It can't go anyplace else legally. Second thing is, those provisions can require that she get a premarital agreement. So here's the problem. Let's say that that my spouse passed away. And so, and let's say that I'm 87 years old, and I'm pretty spry, and I'm getting around, and I met the nicest lady. And she's a good bit younger than me, but man, we've really hit it off, and I'm just like a new point in my life. I'm so happy. I was so lonely for so many years, and it's just wonderful. And so, we're traditional, so we're going to get married. And I know, because I have a lot more money than she does, I know I should get a prenup. But I can't bear the thought of breaking this mood. Honey, I love you. I'm so glad we're planning this. It's the most wonderful thing that's happened to me. I'm so pleased. But I need you to sign this document giving up your rights to all my property. That's your prenup, right? People can't do that. It's so hard. So the provisions in this it's not to make life hard for Mary. It's to make it easy for Mary. Mary's going to say, Ralph, I love you. I hate to bring this up. But when Bill and I did our planning, we put provision in our estate planning that if we remarry, we have to get a prenup. And I just got to get it done. If I don't, I'm going to lose control of part of the estate, which is true. So this is not to create an obstacle. It's to make it easy for Mary to get a prenup. That's the whole point of that thing. And it's a huge protection. I guarantee you that if you have people marry in their 80s or earlier, any second marriage situation, late season second marriage situation, it will, and there's no prenup, it is going to foul up the estate plan. Period. Okay? The prenup is necessary. And that ability to protect half of the estate is really powerful as well, as far as protecting the family. And using the trust is powerful because the way this should be set, here's the problem. In these late season relationships with spouses or girlfriends or boyfriends or caretakers, what happens is that the property gets shifted to the healthier younger one, right? And so it's a perennial problem. How do you avoid that? If I get to where I can't manage, or I'm running on a slow speed, if my setup brings my kids up as my backup, or they're already co-trustee with me, this prevents the property from shifting easily to my new spouse or caretaker or whatever. So it's a huge protection that the trust offers in this late season period of life. Okay, maybe I beat that to death, but it's certainly come up in my practice a number of times. Yes, ma'am?
I know a lot of people, they just get together, they don't get married.
I'm so glad you said that. In Texas, we have common law. Okay, what this means, this is so dangerous. If anybody says you're married, you're married. That's how dangerous it is. Okay?
In Texas?
Yeah, in Texas. Okay, so here's how this plays out. So let's say that my lady friend and I, in my example, she's got a pretty good sized estate, and I have my estate. And, it's not like one's right bigger than the other. And I have my planning, and it goes to my kids. She has her planning, and it goes to her kids. And we say, that's fine. I'm not messing with your stuff. I want mine, you want yours. That's just perfect. We'll just be friends. Okay, so then my new bride passes away. Okay? And so her kids are settling her estate. And they're talking to the attorney that's helping. And he says, was your mom married? And I said, well, she lived with this nice fella for several years, the last several years. And he said, well, were they married? And, well, they held, sometimes they call themselves Mr. and Mrs. or whatever. And the attorney's going to say, well, you have a claim against your wife's spouse's estate for whatever community property interest she owned. Okay? Now, so in other words, now we have this agreement. We never expect any trouble. But the attorney working with her kids is saying they have a claim against my estate. Are we having fun yet? Like, what is this going to? So the attorney says, I can help you with this if you want to. And the people say, well, if we have a claim, sure. So he sends me a letter and he says, I understand you were married or cohabitated or common law marriage beginning back in a few years ago, and I want an account. I want to know the value of all your assets when you all hooked up, and then I want to know the value of all your assets when she died. Could you get that to me pretty quick? Because the difference is likely community property. I'm telling you, dangerous. And in my example, well, if the wealth is unequal, this just gets to be really a high motive.
Hers isn't protected either. So what would you suggest? You suggest this.
Prenup. Cohabitation agreement. We have cohabitation agreement. Yeah, absolutely. Yeah, Texas is just super dangerous on this. Super dangerous. Okay. That trust that we talked about that Bill could have created for his wife to protect his half for her and then to go to his kids. So it couldn't, the remarried side. That same trust, the assets in that trust aren't an available asset for Medicaid qualification. This means if Mary went into the nursing home and she's trying to get qualified for Medicaid, the assets over here in Bill's half of this that's in this trust and Bill's half holds his half of the estate is not countable. So it just takes it off the table. So the part that they've got to do something with or spend down for Medicaid qualification would only be married side. So in states that are for a lot of middle class people, that might be a way of avoiding and simplifying qualification for Medicaid if you ever get into a situation with long-term care implications. Also, in my example where the guy had the wreck and the 7 cars were involved, the assets that are in Bill's half, they're not available to creditors in Texas. So we have asset protection by setting that up. Okay, Mary gets Alzheimer's. With this trust, let's assume that she named her daughter as her successor trustee or co-trustee, and that she had her daughter as as her agent under her power of attorney. So now her daughter has control of the assets and can take care of Mama, and the son does not have control of those assets. No legal control of them. No control of the accounts. What's that?
What if she won't?
What if she won't do the planning?
She's in charge, but she's not going to help Mom.
Well, if you choose the wrong person as your agent or trustee, that's a
But
problem.
you never know for sure. That's the problem.
Well, perhaps. Right, but that's like problem one. For some families feel very comfortable with their own kids, or at least some of their kids. If we're not comfortable with we need to find somebody we're comfortable with. That's all we say about that. Okay, in Mary's case, in this slide, we took the approach that she couldn't qualify for Medicaid, and they ended up paying. I put in that new number. So if she was in there 14 months, that's about $100,000 before she passed away. Now, I put a note here. In smaller estates, the planning might protect half the estate and speed Medicaid qualification. Let me mention a couple of things, though, about Medicaid qualification, just to give you an idea about the possibilities of qualification. When you say that you can only have $2,000 in countable resources, it surely sounds like you have to be completely broke. However, keep in mind that the home you have, up to $500 and some odd thousand, is not countable. And so owning a home will not prevent someone from qualifying for Medicaid, up to that 500 and something thousand. Also, they changed the rules here not very long ago. And now, if someone has an IRA or 401k, and they're over 70 and a half, so they're taking minimum required distributions out of it, it's not countable. Okay? So this means that a lot more middle-class people can qualify for Medicaid with some planning. And so that just gives you an idea that it's not out of reach for families that have some considerable assets.
Are you saying the whole IRA or the RMD is not countable?
The IRA. The IRA. Yeah, the income would be countable, not the, it would be countable income. Remember, there's an income threshold, and if you're over that income threshold, then you have to have a Miller trust or a qualified income trust. We prepare those if necessary. You only need one of these trusts if you're trying to qualify for Medicaid or you're on Medicaid. That's the only time you need a Miller trust. You don't need it otherwise. Okay? But that's how we deal with the income issue. Okay, will marriage estate have to go through probate? Not if we have that trust and the property's in the trust. And if we follow our mode, there's going to be a place to record information about all the things that were good family traditions and memories of Mary, the mother of his family. So now the trust has provided us a way to smooth over all these potholes if we play our cards right, get this trust set up correctly, make sure it's properly funded, and that it's kept current, right? So we can avoid a ton of problems. Now, the thing we haven't talked about down here yet are the Susan and John. So let's do that. So let's imagine for the moment that, remember, her estate doubled during her life to about 1.4, and then she spent about $100,000 in the nursing home, and so we're going to imagine that the estate was 1.3 million. And so what is it? Remember, that simple will is just equally and outright, but the trust could do other things. And so if it's going to go half to each kid, well, we're going to have $650 to each one of them. So this brings me back to this example. You know, if you have a toothpaste tube and you squeeze all the toothpaste out of it onto your countertop, you can dip your toothpaste in it a few times before this stuff gets too dried out to be useful as toothpaste. But you can't get it back in the toothpaste tube, right? And so the analogy at work here is that sometimes it might be better to keep the property in a trust, okay, than to go ahead and spill it out so John can waste it, right? So let's talk about that. So we've got different situations. So maybe we need different trust provisions, right? So Susan, the daughter, is a CPA. She is very responsible. She can manage money. She's frugal. She's prudent. Her husband isn't, but she is. And the concern is that if that marriage ever folded, they divorced, the Bill and Mary don't want her to lose any of that in a divorce. And as I mentioned before, if it goes straight to Susan, if they have a divorce, Jason's going to get some of it. So we could create a family legacy trust for Susan. This would be a trust created by Bill and Mary in their living trust. And it says, after we're both gone, put Susan's property in this trust. And Susan can be the trustee. Remember, the trustee's got the checkbook. The trustee decides how the money's invested. The trustee decides how much to distribute to the beneficiary, and Susan can be the beneficiary. So she's deciding how much she gets out of this trust. However, the property inside the trust never picks up any community property character. Okay? So in a divorce scenario, this trust is not community property. And this is the best way for you to provide a kind of a automatic prenup for any inheritance you leave your kids. Also, it can be tactful, okay? She could, this is not a good example, but where the family's strong and they're not expecting any problems, Susan could name her husband as co-trustee or successor trustee. However, that does not make him a beneficiary, and it gives him no right to the underlying assets. He's there to carry out the terms of the trust, which presumably say to take care of her, and then if she died, it would go to her kids. Okay? So it can be perfectly tactful, and it provides this protection that's very reassuring to most parents if you set it up that way. And you say, well, why does it work? It works because somebody other than Susan created an irrevocable trust for her. Somebody other than Susan put the money in it. And somebody other than Susan set up the terms of the trust. Okay? Susan couldn't do this for herself. Her parents can do it for her, though. And the other thing that this trust provides is asset protection. So if Susan got sued because she was a CPA and no telling what it might happen, she gets sued. The property in this trust is not available to lawsuit-type creditors in Texas. So this is powerful asset protection for your kids as well. Okay, so that's one nice. See, I hit the button wrong here. So we have pretty soon. So we have a different situation with John's trust. He can't be trustee because he's not trustworthy, right? He can't manage this thing, so that's out, okay? So then what families do, they say, well, how about if we made our daughter trustee of John's trust? No. There's no happy ending to this, okay? They will kill each other, they'll hate each other. It won't work. Now, if Susan had any sense, she'll just resign if she gets that appointment. So you don't want to do this. So unfortunately, in this situation, they need to name a third party as trustee. And they probably don't want to inflict this on any family member, so it's probably a bank trust company has to handle this. Now, what is the advantage of that? Let me see, I think I have a thing on this. The advantage is huge. Here's a guy that's got IRS problems. He's irresponsible. He's not going to be able to manage this money or keep it. If you set up this trust for him where the bank controls the distributions, it's not going to be available to his creditors. It's not going to be available to any spouses or marriage situations. But it could provide, the money could be invested and provide for him for the rest of his life. Okay? So in the situation where you have the irresponsible beneficiary, that kind of trust is a possibility. I know families don't like that at all. They don't like it because they don't like the idea. They always hope that their son or daughter will improve and things will get better. And you can put provisions in there that say if they improve, that they can gain control of the trust. So we can put provisions into that effect if necessary. But at any rate, that is one option if we have somebody that just can't manage without having somebody else run the money. Now, I want to digress for just a second. If you have a child or person with special needs in the family, then you want to create a special needs trust for them. And the reason you want to do this is the special needs trust, if that person is receiving SSI and Medicare perhaps, then if they receive an inheritance, they're going to be disqualified from Medicare and SSI. And in some cases, that support is very valuable. It may be providing the place where they live and all kinds of support that just wouldn't be, it would be very difficult to duplicate if it weren't for that government program. And so if the family does not want to disqualify them, what they need to do is create this special needs trust. And the other nice thing about it is that if the person with special needs were to pass away, the money can go back to the family. Whereas if you set it up through a court, or it won't go back to the family. The money will be lost if the court uses a court-created trust. So this is a very desirable way if we have somebody in the family that has a special needs to handle that inheritance. We want them to have the money, but we don't want them to be disqualified. And in this circumstance, it may make sense to make the healthy son or daughter the trustee, depending on the family dynamics. Okay, so one more defining moment. How will you be remembered? What most people leave behind, or a lot of people, family disputes, court hassles, fees, taxes. But you could leave behind planning that works. Your memory is a good steward. And that's actually why you're here. Think about how to make this work okay. And so I know that's what you want. So why do we do what we do? Well, like I mentioned before, I've been doing this a long time. It started out, I wanted to make a living doing something I felt was constructive. But I've been doing it so long now, I feel like it's my calling. And so we're delighted to be able to do this. And in order to do it, it turns out that, strangely, I'm in the same boat as you are. Okay? So I know all about estate planning. But if I had that stroke or I pass away, my wife doesn't know. Our kids don't know if we both got run over. And so I want the law firm to continue. I want us to maintain the kind of expertise that's able to help our clients navigate these things. Also, you need to have a relationship with a law firm that you're comfortable with. And you say, well, I wasn't really thinking in those terms, but here's why this is the case. Your estate planning needs to be updated every few years, most likely. And you'd be a lot more comfortable, you and your family, if you had a good relationship with a law firm and you could go back periodically and check when things need to be done. And one of our goals in the law firm is to send out newsletters and information, and also to have in-house workshops for our clients to keep them up to date, and to let them know when what they might want to think about if they think it's getting time to update their planning. So hopefully we're going to live a long time, and if we do, we need to update our planning periodically. So we want to have a relationship with some kind of law firm that we're comfortable with. And what do you want from that law firm? You want to have certain continuity. The worst thing is you keep getting conflicting advice. What you want is someone a law firm that's interested in the success of your planning and gives consistent advice. And that's what I want for my family too. So that's how we're kind of related on doing this. Okay, so knowledge is not enough. We need an action plan to get this done. So what do we need to do? How do we make it happen? When should we get started? And what's the investment to get it done right? So let's talk about that. So what's the process, right, to do this? Well, it's intensive for both the law firm and for you, because we have a number of steps. The first step is a personal consultation. We'll talk more about that. That's when you're going to express to me the things you're most concerned about, and we want to make sure that's built into the plan. The second meeting we have is when you bring in your account statements, the deed to your house and so forth, because the account statement for your IRA, all your assets, because we want them to flow the way you want them to flow. And that means some things need to be in the trust. We need to update beneficiary designations, maybe change the way the beneficiary designations are set up. So we want all your estate assets to flow with your plan. And then the law firm's got to develop the plan, and then we're going to have a meeting to do the formal signing and funding. Funding is when you sign the deed to your house, conveying it to your trust, and where we do the letters to the bank and the letters to the financial institution and the IRA beneficiary designation forms and all that sort of stuff. And then we want to keep the communications going. And sometimes this step 5 is actually 2. We'll have the signing, and then we'll have another meeting for the funding, depending on how complicated it is or how long it might take. Now, I skipped step 4, but not because it's not important. This is optional. This is a workshop we offer, and typically we offer them every month, so clients coming through the law firm have an opportunity to come to this, and it's called Overcoming the Obstacles to Successful Retirement and Family Legacy. And so, I'm a financial advisor. I'm licensed as a financial advisor. And so one of the things I want to do is try to help you if I can, or if you need help. And so this obstacles workshop, you should have this little flyer in your papers there. And so it says education to avoid mistakes with your life savings. So this is, we need that. And we need to review it from time to time. A vision for your retirement or for your financial goals. We need that. And a lot of times we kind of operate in the land of wishful thinking, so it's nice to bring a little more attention to that idea. And here's one of the biggest deals that families are mentioning, and it's like it doesn't even come up, and it should. Maybe it does come up in some families, and it just doesn't go anywhere. No continuity between the spouses and the children in the handling of investments. This causes a lot of big-time losses for families because of that lack of continuity. In other words, the husband and wife and the kids really aren't on the same sheet of music about how do you handle investments. It's like everybody does their own thing, and when it happens that they get control over it, and frequently this doesn't have good results. And the family would do much better if they had more continuity in their planning. So that's what this workshop, it's a workshop that's given, we have a facility next to our offices at Greens Point where we give this. And so I encourage everyone to come to that. Now, and like I said, I'm a financial advisor, so for some people would like help with having a financial plan or a financial analysis. As a CPA and financial advisor, I can start the process with that if you want, and then I can help you with your investments if you need it. But that's a discussion for another day. But anyway, I just wanted to let you know this workshop, though, I think is helpful to anyone, even if you don't end up working with us. Okay, so that's the overall picture of this. Oh, let me back up one other thing, just so you have an idea. From the initial consultation to the delivery of your documents, we're talking about a month or 5 weeks, just to get an idea about what the time frame is on this. Okay. Now, what's in this big red book that you're going to get? You're going to have your living trust, and then whatever sub-trust you've set up, that may be set up for protecting your spouse or protecting your kids, are part of that same trust document. Okay. You're going to have a will. Wait a minute, how come I'm going to have a will? I thought we were trying to avoid probate. They're called pour-over wills. It's in case you leave something out of that trust that's probate property. Remember, if you have any probate property, you need to have a will. And they're called pour-over wills because they only have one provision in them. They say, if I left something out of that trust, put it in the trust. Okay? But it's going to cost you $3,500 to get it in there, okay? Because remember, it's going to have to go to probate court. If you have probate property, it's going to probate court. It's better to have a will than not have one. This will just puts it back in the trust if you left it out. But we want to avoid that. Now, we try to help clients avoid it. We talk about it a lot, but things happen. You know, years pass and something's outside of the trust. I had one family, and they had a big estate. I mean, a good-sized estate. And they had a lot of mineral interests, and they had land in West Texas and all kind of stuff. And so we had spent a lot of time funding this trust from the get-go. Well, I think the trust was done in 2005 or so, and then the mom had passed away, and one of the sons had come up with Dad as co-trustee, and the son and Dad had been co-trustees until Dad passed away. And we had checked the funding. They'd updated their trust. They'd been very conscientious about it. And so after Dad died, the son had control of everything, right? He's co-trustee and then successor trustee. He's got control of everything, so he starts working to settle the estate. So he went to the bank because he wanted to look in the safety deposit box. So he goes to the bank and he gives the people there, he says, my dad died, here's the death certificate, and I need to get in my dad's, get into our safety deposit box. And the bank guy said, you're not on it. So he couldn't get into it. And they said, well, you can look in there, you can't take anything. So they let him look in there, and sometimes people don't have anything in their safety deposit box worthwhile, so he could just ignore the whole thing. But it had like $20,000 worth of gold coins in it. Okay, and so what had happened is this safety deposit box had been in the husband and wife's name, right, as joint tenants with right of survivorship. Mom died. Well, Dad still had access to it, but it had never been put in trust name, and that's why he couldn't access it. And so we had to go to probate court with the pour-over will, and he had to pay the cost of going to probate in order to get control of gold coins. But I guess it was worth it, but it's sort of an aggravation when everything else was part of the trust. So that just gives you a little bit of idea about the portable will. Then this is your financial power of attorney. This is your healthcare documents. This is your HIPAA is the authorization for people to access your medical records. If you don't give them authorization, they can't access your medical records. Now, we're going to provide you with these documents, but we're also going to do something else. And as far as I know, we're the only law firm in Houston doing this. One time I think we were the only law firm in Texas doing it. And this is not because I'm so smart. This is because the American Academy is so smart. At any rate, we're going to provide you with a video. Okay? This is a video that gives an overview of your estate planning documents, and it has the specifics on who your executors, trustees, and agents are. Okay? And it's not 5 minutes. It's around 55 minutes. Okay? So, we're going to give you a copy of that on a flash drive, along with copies of all your signed documents. So the idea here is that if you need to refresh your memory about how your trust works, you can watch this video. If you need to talk to your son or whoever your backup family trustees are, you can show them this video. And so I think this will make people a lot more comfortable with their documents for a longer period of time by having this. So I just think this is the best thing since sliced bread. Now I've delivered thousands of them myself, and we would spend a lot of time with the clients, but it's so much information, it's hard to retain it. And so I think this is a big help to clients to provide this. So that's part of our deal. And then we're going to have this extra section in your book that has a lot of questions. A lot of them are fun questions, but about your life. And it's a place to record information about you and your family that might be meaningful to your kids and grandkids. Okay, you say, well, wait a minute. Okay, I'm going to get all this thing set up, and then the law's going to change or something's going to change. And I just can't bear it. And so this is a reason why we put off stuff a lot of times. And this is a really good point. Remember, the best time to do your planning would be right before you die or have that massive stroke. There's no better way to do it. Wait till then. Except the problem is the timing, right? So since we can't time it that closely, guess what? And also, we want to live a long time. You're going to have to update it, and things will change. And that, like I said earlier, that's the reason you'd be a lot more happier if you were comfortable with working with a law firm, hopefully with us. Okay. So remember I was going to ask you what's most important? So I hope you'll kind of crystallize that for yourself from the things we've been talking about today. What are things that would be meaningful to you? If you're going to come talk to me, that's what we want to do. We want to make sure we address those things. Because what's the most important thing to us? It's making sure that what's important to you is in your plan, right? That's the gist of the problem right there. And this whole deal with using the bare bones stuff is not going to give you the peace of mind that you want in this process. Your plan could potentially last for generations. It needs to be well done. Now, the dirty secret is that a lot of times these trusts don't work, and why is that? It's because of what I mentioned earlier. They're not properly funded. Many law firms that do living trusts, the funding they do is they'll do the deed, and then they'll give you letters about how to handle the rest of your property and instructions about. In my experience, this does not work. We work closely with our clients to help you get the property properly funded. It also requires your effort. You got to make sure you do a good inventory of your stuff and give us enough information so we can help you get it properly funded. So you could have the most beautiful documents in the world, but if they don't deal with the issues you're concerned with, and if the trust isn't properly funded and your beneficiary designation's aligned with your planning, it's worthless. So it's going to take expertise, time, and persistence to do this. It takes your effort.